Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court is open, please be seated.
Lost an appearance. Good morning. Welcome to the Appeals Court. I am William Meade. To my right is Justice Blake, and to my left is Justice Desmond. We'll be the panel for all the cases today. If you haven't been here before, you should know that we've read everything. Each side gets 15 minutes. There's no rebuttal. My best advice is to get straight to the point. And with that, I'll call the first case. It's 22P550, Commonwealth versus Gill. Mr. Conley.
Thank you. May it please the Court, Alex Conley for Ms. Salome Gill. Starting first with the identification issue in this case, when dealing with the prior familiarity exception to the general rule from Creighton that a first time in court identification is a show-up that's inherently suggestive and shouldn't be permitted, the cases use specific language as to what the prior familiar has to be. The language that's often used is things like extensive and intensive or repeated and prolonged. So I agree with the Commonwealth's brief in this case. It's not that you have to have a prior personal relationship with somebody, but you have to have the kind of familiarity with that person of extensive, intensive, seeing that person, being able to recognize that person as somebody you previously have seen or know. I think the sufficient interaction has to make that identification, when it's done in court, reliable, that it was somebody you recognized from previously and not something else.
Wasn't the evidence that he was familiar with them, familiar with her because of her relationship with his cousin, and that he had seen her with his cousin on various occasions, whether it was in a Snapchat or I think stories they called it. I'm not up on the social media lingo, so I don't know exactly what that is, but as I understand it, it's a little longer than a clip, I think, and you can last for 24 hours, and he had seen her at various restaurants and at nightclubs with his cousin.
So the evidence that came out at trial from the witness was first asked, do you know the defendant at all? He says no.
Right.
So all with that part in mind, he then goes on to say, I've only seen her in my cousin's stories, presuming we're talking about Snapchat or Instagram stories or something, which in any event, as Your Honor said, is some type of short clip, maybe it lasts. And then after a compound question is asked about where have you seen, do you know her in person? Have you seen her? He just says, I've seen her in bars and restaurants with my cousin, basically. And that's it.
So why isn't that sufficient for familiarity?
Because there's nothing in there that indicates any extensive, intensive familiarity.
Does it have to be? I mean, I come in the courthouse every day. I may see other people who work in the courthouse every morning who I come in here. I recognize their face. I know they work here. I don't know them. If you ask me, do I know that person? I could say, no, I don't know them. I might not even know their name. But I know them. I see them every day.
Yeah, I think if there were more evidence of something that this person has seen every day, that would be a different story. This is somebody who says he doesn't know, and he's seen her on Snapchat stories basically only. Doesn't say he's seen her his cousin is with her constantly and on every Snapchat story for a
He called her Salome? He knew her by Salome?
I think the Commonwealth indicated in their representation to the court at the motion in limine that he knows her name to be Salome.
Pretty unusual name, right? And that is her name, right?
Yes, that is, I would suggest, the Commonwealth's representation didn't accord with what the witness actually testified to when he said he didn't know her at all. And that is a representation from what he's been told now, where he's identifying the defendant in court in front of him that he knows is Salome Gill.
Could I ask you, on page 20 of your brief, you bold the word significant when you're describing the Fielding and the Ortiz cases. I don't see anywhere that significant is a requirement, a significant relationship. Was that your emphasis? That's certainly not in the cases, right?
Right. I believe that was my own statement, not a quotation. So that's.
Do you think the cases say that a significant relationship is required?
I guess My wording of the relationship, I might walk back on the relationship aspect of it. I would say it's a significant period of being able to see and know who that person is. And that has to be something significant. I think fielding, which is cited throughout my brief, the Commonwealth's brief, my reply brief, is a good example of the kind of familiarity that's...
Let's look at it from a different angle. In Creighton, what the SJC was concerned about, when there isn't a prior out-of-court identification, when you bring the witness in court and they're allowed to make an ID, they say it's similar to a show-up and it can be suggestive. But if given all that and you've seen the person on videos out in public with your cousin and you know what her name is, why isn't that sufficient to overcome the concern about an in-court ID being suggestive?
Well, I think that the backdrop of Creighton and the constitutional concepts behind it are all about whether or not that would be something that is sufficiently reliable to be there. And I think when you look at a case like this, for example, to say that having seen somebody on Snapchat a few times in various places would allow you to actually have a reliable identification. Yes, that's the person I've seen.
So, but you're saying it's impossible for this to have been okay with the limited exposure he had to the defendant?
I think based on his testimony, it was well short of what would be sufficient.
No, it has to be outside the realm of possible alternatives. We're reviewing for an abuse of discretion.
Oh, yes, Your Honor. I think that it would be impossible for the judge on this limited factual scenario that's been presented to him in the evidence to say that's sufficient, because they need to show under the case law, like I said, the words that are used are extensive, intensive, prolonged, and repeated. And that's just, there wasn't evidence of that to allow that to come in. And I think that would be an abuse of discretion to say that is somehow extensive and intensive or repeated and prolonged contact that would allow that.
I don't want to belabor the point, but certainly repeated fits, right?
I think, I mean, even the Commonwealth's representation at the motion eliminate hearing was, we don't know how many times this was. He couldn't tell us.
I know it was more than one.
We know it was more than one. And unless the court's able to say that anything more than one is enough, I don't think that passes muster under the reliability as required. As it relates to the prejudice arising from this particular error, I think that if error is found here, the Commonwealth's closing is all about, starts with the phrasing. He pointed to Ms. Gill 3 times and then emphasized throughout it. So I don't think I think that is clear that there'd be prejudice here. It's all about identification. The entire argument by the defense at closing is about identification.
Is your client out of jail now?
She is out of jail now. There was a stay of this 30-day sentence granted. She remains out of custody until.
So she's not served the sentence on this case?
She's served a few days of it between the sentencing and between the conviction and the sentencing.
Okay.
Other than that, there's still 25 odd days remaining. Moving on to the next issue with the Rule 38 issue, I think that there's as far as there is some, at least, error here, I think conceded by the Commonwealth. Procedurally, this wasn't the judge's.
Does the motion eliminate judge count in this analysis? And I think your answer is yes, and I don't see why.
So I think that this is, it seems to be an open question, and there's no case law that says one way or another definitively, yes, this counts, no, this doesn't count, and I concede that. I think the Commonwealth v. Napat case, the 128 decision that the Commonwealth cites, where this court says similarly that there's no law on this matter, the defendant can't point to anything that says it does count.
What if the motion eliminate judge had heard this motion, 3 weeks before trial as opposed to the morning of? Does that change your analysis?
I think that what would be required is that the judge at the trial would have to indicate some kind of familiarity with that decision, because that's what the reason behind Rule 38 is, to make sure that the judge who's hearing the evidence understands the whole scope of what happened
And the
previously.
familiarity is more than just allowed as to this witness, denied as to this witness.
I think it needs to be, because you can see the issue in this exact case where it's not. If all he has is, well, it's denied to this witness, he's not going to be in a position to say, well, now that I'm hearing this evidence, I don't know if there was a voir dire previously of this witness. I don't know what happened to that motion to eliminate that allowed him to do this. But if it's just based, whereas here it was just based on a representation made by the Commonwealth as to the level of familiarity, and then in fact his testimony differs from that representation, that prior judge would be the one who could say, wait a minute, that's not what you guys said at the motion to eliminate. You didn't say he didn't know her at all, and now he's saying he doesn't know her at all. That judge would be in the position to say, let's reconsider that.
Is the motion in limine part of the jury trial?
And again, it's an evidentiary decision prior to a trial for the trial. I mean, it's less akin, I think, to a motion to suppress or something like that than a trial decision, because it's about the evidence right before trial, what's going to come in and not.
Do you know if the motion in limine was before or after the Commonwealth moved for trial?
I'd have to review the record to just see about that. I'd assume just in the kind of day-to-day operations of the court, the motion for a trial comes either when their trial is scheduled or when the Commonwealth says they're ready to go. I believe in this case the Commonwealth would have reported ready for trial prior to the motion to eliminate. I can't answer that without looking back throughout the record definitively. As to the ineffective assistance argument and the continuous out of finding of the...
One more question on
Yes.
the second judge. I'm going to call him the second judge. I'm going to call him the third judge. Wasn't the third judge's ruling with respect to the, I think her name was Cepeda witness, consistent with what the second judge had ruled?
It was ultimately, after the objection was lodged at trial, that Cepeda could not identify the defendant. She did in trial despite that ruling. The objection was lodged. It took a sidebar conversation to basically, and unfortunately the record was inaudible as far as what occurred, but presumably they had to tell him that no, there was a motion to eliminate. They said that this witness could not identify her. Then he sustained the objection. Regarding the ineffective assistance and the denial of the motion for new trial as a result, first, as the point I want to make is that the judge, the motion judge here, he basically adopted in full the Commonwealth's opposition. He didn't not make findings. He basically found, I agree with everything the Commonwealth said. So as far as that is concerned, I think when looking at whether his findings were adequate, we have to reference what he references, the Commonwealth's opposition. And this is important because there's a lot of things in the Commonwealth's opposition that are simply not in the record, such as whether or not they would have offered the continuous out of finding, what their notes on their file said, what their past witness contact was.
But if you read the transcript, and please correct me if I'm wrong, it didn't seem like the Commonwealth was offering a quaff. They said something like, my words, I'm paraphrasing, but she doesn't have a record, so she might be entitled to a quaff. But do you think that's an offer?
I don't think it's an offer, Your Honor. I think that's the standard we're working with here. The standard is there a reasonable possibility that the Commonwealth would have offered a different plea, and that the court would have accepted it?
Well, the prosecutor says at sentencing that I did not offer a quaff, and this is not a type of case that someone should get a quaff.
That's what the prosecutor said after the conviction in the sentencing hearing, when the attorney said, well, you guys said a quaff at the time of the prior to trial.
So the two other things in play. The defendant says she doesn't ever remember being told about a quaff. Okay, so the judge doesn't have to credit that affidavit.
Well, Your Honor, that again comes into the point with the judge's findings being so lacking here. He didn't he didn't credit that. And the Commonwealth's opposition doesn't actually
sometimes things are implicit. But on top of that, we have trial counsel's affidavit where she said she did discuss a quaff.
She does indicate she'd mentioned a quaff. She is hesitant to, she does also say that she didn't discuss a quaff and the felony conviction and the possible consequences of a quaff as she would normally do, as she basically, without putting words in her mouth, exactly what she would want to do in most cases. She did less than that, less than what she as an experienced attorney would do under these circumstances because she was so sure this was a triable case and a case that needed to go to trial.
Where the judge sentenced her to committed time, you think it was likely that the judge would have taken a quaff?
Well,
Which is one of the things you got to show, right?
you have to show a reasonable possibility. I mean, what we have at the time pre-trial is the Commonwealth saying she's entitled to a quaff. If there were a agreed-upon plea put before the judge with a quaff on it.
Do we think that the Commonwealth said she was entitled to a quaff because of the facts and circumstances of the case, or because she just came to the court with no prior record?
Well, I would imagine, just given the Commonwealth, the district attorney who was answering on the case was familiar with the case at the time she said that. She was getting ready to try it that day. It wasn't something that she wasn't aware of the facts and circumstances when she said she is entitled to a quaff. And those were her particular words. And also the court's own suggestion, has a resolution been discussed, in practice often means they're trying to hope to get a resolution to make all the parties agree, thinking that if an agreement's made, the court might be inclined to accept it. So I think with that, the reasonable, and again, the standard being a reasonable possibility is not.
He stabbed her in the head with the keys and caused significant injury to her, right?
There was an injury to her head with the keys, correct.
Okay, thank you. Ms. Cohen.
Thank you. Unless there's any, I'll rest.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. I suppose I'll start with the ineffective assistance of counsel claim. The Commonwealth first argues that the representation provided by trial counsel was not ineffective, and that is based on trial counsel's own affidavit that was submitted as part of the motion for new trial. Perfection is not what is required as part of the representation. There's the standard that has to be met is whether the representation fell below that which an ordinary fallible lawyer would have provided. And I believe, based on the affidavit, that can't be said, and that the defendant cannot meet the first prong of Safarian. It's clear from the affidavit that counsel discussed a quaff on more than one occasion, discussed the potential of a plea on more than one occasion, had multiple telephone calls with the defendant over a period of time. And it does appear that she left the ultimate decision on whether or not to proceed to trial to the defendant. If the court disagrees and finds that there was ineffective assistance, the Commonwealth would also argue that the defendant is unable to meet the second prong of Safarian, which in the plea context requires that the defendant show the Commonwealth would have made a more favorable offer than the defendant received after the trial, that the defendant would have accepted that and the court would have approved that. While the Commonwealth did make a statement during the motion in limine phase that the defendant would be entitled to a quaff, I argue that that is a recognition that the defendant could ask for a quaff and one could legally be given to the defendant had the judge approved a disparate plea. I don't think that that statement says in any way that the Commonwealth would have made that offer, and I believe the Commonwealth statement post-trial confirms the fact that that was not the offer of the Commonwealth.
An argument could be made that the government would have offered something less than committed time, though, right?
Well, I suppose that's possible. However, given the facts of this case, the fact that the victim was apparently on board and appeared for trial 2 years after the incident, that there was a significant injury, that the victim went to the hospital after the injury and also provided multiple victim impact statements, I think this is a case where the Commonwealth likely would ask for jail time and did ask for jail time.
Does the record reflect how long the assistant DA had this case? In other words, was she familiar with it?
I don't believe the record reflects her familiarity with the case, no, Your Honor. I guess I'll backtrack to the identification issue if there's no other.
Before you do that, on the ineffective claim, a second piece, at footnote 11 of your brief, you suggest that the defendant has waived her ineffective claim as it relates to the substitution of judges, but she does raise it in her appeal as a substantive issue, albeit on a substantial risk analysis. So is it waived in the ineffective claim? You say it's relegated to a footnote, but it's a substantive argument in the brief on the direct appeal.
I still argue that the issue is waived at this stage. I argue that at this point, that wasn't an issue that was briefed for this panel significantly. It was a footnote, and frankly, I addressed it as a precautionary measure.
Procedurally, does it really matter, though, because under Randolph, we have to look at whether a substantial risk occurred, which eclipses the Safarian equation anyways.
Yes, Your Honor. Just moving to the identification issue, if that's, Justice Desmond made a good point.
He does that.
Which I think is something that I would have mentioned, that, you know, he sees and we all see people every day that we recognize by face. And we may not know them as in we're not friends with them, but we easily recognize them. And I would argue that the Commonwealth's representation to the court of the anticipated testimony was not that there was any, that it was never argued and has never been argued that these two people were friends or actually had had any in-person conversations. But I think throughout what's been argued is that being able to view somebody and become familiar with their face through repeated exposure by videos and in person is enough to meet the good reason standard from Creighton.
Well, it's interesting. You do rely in your brief on Fielding, and you say this is similar. But Fielding requires, quote, an extensive and intensive opportunity. On this record, do we know that these observations were extensive and intensive?
Well, Your Honor, I compared this case to Fielding primarily because of the reported cases that I found.
Right, there was a lot of unpublished that you cited.
Yes, and I think that the facts of this case fall somewhere between Ortiz, which is obviously disfavorable, and between Fielding. And the law does say that it's an intensive and extensive opportunity to become familiar. And I think based on what was testified to, that isn't precluded in this instance. I think the witness testified to viewing videos, plural, stories, plural, seeing this person in different businesses, plural, bars, plural. I think that's at least 4 opportunities to view this person, if not 8. Turning to the substitution of judges issue, I, of course, argue in line with the Commonwealth and Napat decision, which is unpublished. However, it seems clear that because jeopardy doesn't attach until a jury is sworn, that Rule 38 was not meant to apply to judges prior to the jury being sworn.
So because Judge Desmond asks excellent questions, I quickly searched the transcript for his question, and the motion in limine judge asks the Commonwealth, are you ready for trial? And she answers, ready for trial, not move for trial, but ready for trial. The discussion then takes place about the motion in limine. It's kind of, this is a legal word, squishy about what happened at the start of that trial. For all intents and purposes, it appeared the motion in limine judge was going to be the trial judge. How does the Commonwealth answering ready for trial before the motion in limine is heard impact your analysis if it does?
Well, Your Honor, I obviously haven't had the chance to familiarize myself with the transcript just now, but I do believe that while the Commonwealth answered ready for trial, she did then represent that it would be best for the judge to hear the motions in limine because proceeding to trial fell upon whether or not this identification would be allowed. So I think she answered ready for trial, but then there was maybe an equivocation, and she needed to have the answer to the motion in limine question before actually being ready. But regardless, I would still state that because the jury was not sworn until the impanelment judge, the second judge, was on the bench, that is the the controlling point around whether or not Rule 38 applies. If there are no...
Does the record reflect what happened to Juan,
The record, I'm sorry, Judge.
the fellow that was passed out, that was being dragged around?
So I don't believe there was any, I believe the testimony at trial was that family members stayed with him at the time, just after the incident, when the victim went to the hospital. And then I believe trial counsel represented that he was out of the country for the trial. But
Oh, okay. Thank you. Thank you both.
I'll rest my brief. Thank you.
Something more nefarious happened before Juan. The next case is 23P468, Commonwealth versus Barreto. Mr. Rotundo.
Good morning, Your Honors. Attorney David Rotundo for Mr. Barreto. I'd like to first say that I realize I have a tough burden here. We did have an evidentiary hearing. I was not counsel on the motion, and the judge, both trial counsel and appellate counsel testified. And the judge, deferred to trial counsel's strategic decisions. So I guess the question is, what other actions by the defense counsel would have further protected the defendant? And I feel there's some serious issues in this case regarding first complaint and vouching evidence. Now, the first issue is the first complainant testimony. Judy's mother testified, and she testified that she knew her daughter, she trusted their relationship. She would not tell me this, implying that she would not tell me this if it wasn't a lie. She believed her daughter, but didn't want to believe it. She didn't need to have her daughter examined. Her daughter confided in her. So it's our position that the totality of the mother's testimony is essentially vouching. And the jury would consider the testimony as Judy never telling a lie to her mother. So in that respect...
What impact does this case the direct appeal was decided under our old Rule 128. What impact does that decision have as it relates to this issue of first complaint testimony, which was raised on direct appeal? How do we consider that in view of this now as an ineffective claim?
I don't think it was not raised on direct appeal. Any first complaint issues. I do not believe they were.
I'm happy to be wrong on that.
Appellate counsel did testify, and she testified that she would have raised certain issues. However, the defendant didn't want to delay his direct appeal for whatever reason.
Well, okay, continue.
I mean, so
Isn't it kind of a stretch to say that mom was vouching for her? I mean, I understand, but nevertheless, I mean, mom says, I didn't want to believe her. I mean, I knew she was telling me this. I was kind of chalking it up to, well, maybe she was some type of confusion, and she told mom that he would tickle me and put his hand under my shirt, right? But that's what the disclosure was?
essentially, yes. Yes.
Not that he, fondled me. Really nothing more than that. Doesn't the defense counsel refer to it in his opening argument?
Well, I think, even what she believed, the daughter, even what she believed would amount to, essentially facts that would be detrimental to the defendant in this case, right, to support the indecent assault and battery. It wasn't a rape
Not
charge.
sexual assault. I mean, he put his hand under my shirt. Maybe he's tickling her stomach. Maybe he's tickling her back. I mean,
Right. She didn't want to believe, but, in totality, I believe there are several other issues coming up that, if we look at the whole record in totality, that there was a substantial risk of miscarriage of justice in this case. And specifically, with regards to the defendant, in closing, the Commonwealth used that vouching evidence of the mother, stating, the mother stated, "I believe my daughter, but I didn't want to believe it, so I tried convincing myself maybe this was a misunderstanding," but she did believe her. So I would argue that testimony was improper. Now, further, as we move on, Judy gave testimony also, and she repeated her complaint during direct to her mother, subsequent complaint to her mother and Mrs. Barretto, and she also gave complaint evidence during the SANE interview. So one of our arguments is also that there was lack of limiting instructions by the judge for all those separate instances.
He twice instructed on first complaint when mom testified and then in the final charge, right?
Yes, but it's our position that that wasn't enough, because the first complainant testimony is required whenever the first complaint evidence is admitted, whether through the complainant or the complainant witness.
And you get that from the guide to evidence, right?
Yes.
Yeah.
yeah.
So do you have a case that says the judge has to give a first complaint instruction when the victim testifies about what happened to her?
I have not found a case.
No, me either.
Well, how about I have to give it 3 times instead of 2? I mean, he gave it before the first complaint witness and after the first complaint witness, right?
Right.
Okay,
Right.
So,
strictly, following the rule, it doesn't comply with the rule, and, that's an issue that, we raised on direct appeal. Now, I think the most egregious issue in this case is playing the SANE interview transcript to the jury.
that was a strategic thing.
Excuse me?
And that was a strategic choice that the defense counsel made, right?
That was. However, if defense counsel had the SANE interview transcript, he heard direct testimony, and everything that Judy stated in her SANE interview was pretty much consistent with her direct testimony.
That may be true, but he seemed to suggest that it wasn't so much what she was saying, but how she was saying it, that she was not really serious about it, that she was smiling when she was disclosing this information, that it seemed to undercut the seriousness of the allegation. And so he had a seasoned defense counsel, not a young, fledgling defense counsel.
That's correct.
Who says, I looked at it and I thought, this helps us.
Unfortunately, even, we don't have the recording, but we do have the transcript, and, the recordings, I mean, as far as demeanor, that's something that I really have a tough time arguing against, right? That he wanted, to recognize her demeanor and utilize that. However, what I can say, as far as the prejudicial impact, Judy described 3 incidents of inappropriate touching on page 10 and 11 of the SANE transcript. Then she repeated her testimony regarding all the incidents on page 13 and 20. So we have like double testimony coming in about these incidents. She further testified to bad character or propensity evidence. When she testified, as she gets older, she realized that people should know about the defendant because he was always around children. She was motivated to come forward because there are always little girls at the Barretto house. Again, we have evidence of private opinions here.
How was that propensity evidence? I missed that. How is that propensity evidence that he's always around children?
Well, I'm saying that, that's just an evidence of private opinions, and I would argue that that's her private opinion, and that's inadmissible evidence.
That's in response to why is she testifying? Right?
Why she was motivated to come forward. Well, she stated she was motivated to come forward because there was always little girls at the Barretto's house. She did not feel it was safe. So, again, And furthermore, you know, this is investigative, quote-unquote, investigative process type evidence, a sane interview transcript. You know, they start off where the Worcester DA is interviewing. This is all going on in front of the jury, obviously. They hear everything. The Worcester DA is interviewing the child witness in this special room. They have cameras. There's mirrors. You know, there's an aura of credibility in this process. So I would argue that, you know, better choices, less damaging options could have been made.
That may be true,
and
but
I
of course
realize,
that's not the standard, right?
excuse me.
I said that may be true, but of course that's not the standard that we use.
Well, I think it you know, it's within his. I think it was unreasonable, and you know, it had a substantial prejudicial impact, and I guess I will. I'll rest on that. I don't have anything else. Any questions? Thank you.
Thank you. Mr. Bowden.
Good morning, Your Honors. May it please the Court. Nathaniel Bodwin for the Commonwealth. Before I get into my argument, I do want to acknowledge that the victim and her family are watching this argument on the Court's YouTube channel. In terms of the allegation of improper vouching, I think when you read the mom's testimony in its totality, that testimony was actually pretty nuanced. She describes initially an expression of disbelief, that she did not want to believe that occurred. She talked about her long relationship with the defendant's family. She talked about the fact that she perhaps maybe talked to her daughter a little too much about sexual assault and being careful about those types of things. So I don't think across the board it was an expression that the jury would have come across as the mom believed her. And I think when you look at the cases that the defendant cited to, specifically Lorette, there was a lot more egregious examples there, such as the mother in that case, Lorette, saying that her daughter certainly wasn't fabricating anything, that her story just fit, that her story was always clear, and that she never once strayed from it. And it is true in that case that this court found there to be a substantial risk of a miscarriage of justice, but that was because of other errors that occurred in the trial too, including the prosecutor's closing argument.
Let me ask you this question. If the defense counsel says it was a strategy, I'm going to let the sane interview in, notwithstanding that he says it was a strategy, if it's just so outrageous, can it be ineffective?
If something is so outrageous, a motion judge could say that that strategy was manifestly unreasonable. This motion judge said this counsel's strategy was not manifestly unreasonable.
I understand. That's why we're here.
Yes, yes. And so I think that really, and the reason why it wasn't manifestly unreasonable, Your Honor, is that the entire defense strategy was attacking the credibility of the mother and attacking the credibility of the victim. And all these allegations of failure to object to various portions of the testimony, the defense counsel used all of those circumstances to attack the credibility, mostly of the mom, but also of the victim. So I don't think any of the allegations put forth by the defendant were so outrageous that it reached the level of it being manifestly unreasonable or ineffective. So I think the motion judge properly exercised his discretion in denying the motion. I can move on to, I guess my argument in terms of the mother's alleged emotional reaction, very similar to my argument about the improper vouching. The defense raised these issues in its opening. So the Commonwealth, it was proper for the Commonwealth to then elicit testimony from the mom about her reaction to her daughter's discussions about what occurred. And it was, the Commonwealth was able to do that because they had to basically rehabilitate the credibility of its witnesses because they were disparaged in the opening statement. And finally, I'll just say in terms of the, I believe there was also an allegation made here today, as in the brief, about improper vouching in the closing. All of those challenge statements in the prosecutor's closings were direct responses to defense counsel's closing argument, which was again attacking the credibility of the victim and the mother. Essentially, the defense argument was He basically said, if this was my child or if this was your child, unlike this mother who, quote, did nothing in 2011 when she first heard about it, I would have brought, or you would have brought your child to the police or to a doctor, or would have done something. So then it was, the prosecutor was proper for the prosecutor to then say, using facts from evidence, to say that, to explain why the mother acted in the way that she did, based on the family relationship.
Sure, didn't the defense counsel also say that what mom would let their daughter, who they think was molested, go on vacation with the defendant?
He certainly said that, and the prosecutor responded to that by saying, yes, the mother did prevent the daughter from going there on Wednesday nights after she first talked to her about it, and that the mother did say, and yes, I did allow her to go to a birthday party where I was there, and she had no interaction with the defendant, and then she did say, in terms of the trip to Brazil, that I wanted her to go on the plane with people that she knew. The defendant's wife was there, her children was there.
But she initially
And-
denied that?
Yes, there was some inconsistencies in her testimony about when she knew, about the timing of which she knew the defendant was going on that trip. And again, I also want to emphasize, and it's important for the court to consider, this was a defendant that had 2 charges, was charged with 2 complaints, 2 indecent assault and batteries. He was acquitted of 1 of them. So I think it's inaccurate to describe the representation here as ineffective, that you can argue it was effective since he was acquitted on 1 of those charges. And this whole idea of attacking the credibility of the witnesses instead of objecting to certain testimony was ultimately, to some degree, successful for the defendant.
Do you think that the matter that he was acquitted on was related to what your counsel would refer to as the first disclosure?
So the defendant was acquitted on the touching, the allegation of hand to breast.
Right.
So that would have been the final incident that the victim testified to, about the fact that she ended up on the floor with the defendant, that he was tickling her, and then that it was that incident that then led her to go to her mother and say, I don't want to go to that house anymore, I don't feel comfortable there. So again, we don't know why juries do what they do all the time, but perhaps the defense strategy of attacking the credibility of the victim, suggesting maybe that particular incident was roughhousing or play wrestling, perhaps the defense strategy was successful in leading to that acquittal. And if there are no further questions, Your Honor, I can rest in my brief.
Thank you. Thank you both.
Thank you very much.
The next case is 23P 351, Commonwealth versus Bernhardt. Mr. Corman, welcome back.
Good morning, Your Honors. It's a pleasure to see you all, my favorite panel. For the record,
Flattery will get you nowhere.
certainly not in this case, Your Honor. Good morning, my name is William Corman. It's my pleasure to represent the defendant in this particular matter. From the outset, as defense counsel stated to the judge, a live witness is better than a non-live witness. And with that framework in mind, I think it's important to recognize that the judge erred in not allowing a continuance for a specific articulated reason by defense counsel at the outset of the trial. This is not one of those circumstances where defense counsel was being squishy in trying to figure out why he needed a continuance. There was a specific and articulable fact, there was a witness, there was a reason, and it's especially important to recognize the facts and circumstances surrounding what was going on globally at the time.
Why wait for the trial date?
I'm sorry, Your Honor.
Why wait for the trial date?
I don't have an answer for that. What I would suggest, Your Honor, is using the phraseology this court often uses is, the hurly-burly notions of the district court. Sometimes you have no idea whether or not your case is going to get reached and whether or not you get to that point anyway. There's nothing in the record that suggests why trial counsel didn't seek a continuance ahead of time, so I simply can't answer that.
Let me ask you this question. This witness was difficult to be reached by defense counsel, right?
I'm sorry, Your Honor, I apologize.
The particular witness, Mr.
Marino.
he was a difficult witness to find or to have contact with by defense counsel.
It seemed that way, Your Honor, yes.
So do we know that he actually had COVID?
Again, all we know is that the investigator, per the record, went to the house on, I believe it was Monday, said, we need you to come to court to testify, and the gentleman said, I have COVID, I'm in quarantine. So I suppose the answer to your question is no, but I think that given the facts and circumstances of the case, I think that trial counsel did everything he could to convey to the judge that, we do not want witnesses coming to the court mid-pandemic with COVID and ask for a continuance.
Sure, if they have COVID.
Absolutely, Your Honor, but yes, correct. And I don't know that there's anything in the record to suggest the gentleman did not.
It's difficult to reach.
He was difficult to reach, but nevertheless, he was reached. He was, according to trial counsel, I suppose we have to, there's no reason not to believe what trial counsel said on the record, that his investigator went there on Monday night, talked to the gentleman said, I have COVID, I'm in quarantine.
You have an arguably evasive witness who
Yes.
says, I can't come because I have COVID.
Correct. But on the other hand, Your Honor, he also didn't not answer the door. He didn't ignore the investigator when he came to the house. He didn't shut off all the lights when a car pulled up. There was contact between the investigator and the witness, which perhaps lends some credibility, albeit I don't know how much the court wants to impose upon it, but it gives some credibility to the fact that this conversation took place. And again, it's important to note that it's the defendant asking for the continuance, recognizing that there are speedy trial issues, so on and so forth. I don't think trial counsel was asking for a monumental continuance. Quarantine isn't necessarily that long. Trial courts were getting busier, but they weren't certainly at the place they are now. And I think that, again, given the specific reason why trial counsel wanted this witness to testify, what this witness could testify to, and the fact there was an actual reason as to why the witness wasn't there, compared to, well, we haven't been able to get in touch with the person, we've played phone tag, anything along those lines.
Mr. Corman, doesn't it matter what the witness was going to testify to?
Absolutely, Your Honor.
It has to be something like a central factual dispute, right?
I think that that's one element of it. I think another element of it is there can be testimony provided by a witness that is also collaterally important. I mean, we all have cases where 6 different police officers testify as what they saw.
He was going to testify to the defendant's injuries
Correct.
that were inflicted by the victim.
Correct.
And she herself testified to those injuries.
Correct.
And he testified to those injuries, and he showed his scars to the jury.
He did.
So I don't understand what Mr. Guarino would have materially added to this case.
So there's nothing in the transcripts that indicates that the defendant testified because Mr. Guarino wasn't available. So we don't know. Perhaps the defendant would not have testified and opened himself up to cross-examination had Mr. Guarino been available. I think that the victim did testify as to some injuries that were caused by her to the defendant, but I think that even looking at her testimony in the light most favorable to the Commonwealth, I think that compared to what the defendant said they were, she certainly undersold what those injuries were.
Was there a stipulation? I'm sorry to interrupt you, but was there a stipulation as well?
There was a stipulation, but the stipulation was because Mr. Guarino wasn't there. And that's what led trial counsel to say, a live witness is better than a non-live witness. And I think that the stipulation, quite candidly, when you read it, it's dry. It's dry. And I think that...
Well, the judge pressed them and said that he wanted specifics, and there are 4 enumerated injuries on there. That's pretty specific.
There are, Your Honor, or there is, Your Honor, I should say. Yes, it is very specific, but I think that no one in this room can deny the fact that a stipulation being read in about a dry recitation of injuries would be far different than Mr. Guarino saying, within X number of days after this incident occurred, I saw, the wounds look like this, they were red, they were fresh, they were, whatever the testimony is going to be. And I think that's far more impactful to a jury, especially in a case like this, than a stipulation that's read into the record. I think stipulation was what they could come up with.
There's a not guilty on one of the counts, right?
Yes.
Not guilty on strangulation, and
Yes.
the defense was self-defense.
Yes.
They believe something.
Yes, Your Honor, and I often wrestle with because there was a not guilty on one count, therefore all the defendant's arguments on appeal are blown out of the water. I'm not suggesting, Your Honor, saying that.
But you can't ignore it.
No, Your Honor, except for the fact that the charge of strangulation has some very, very specific elements that need to be proven. And if the court looks at the record of the cross-examination of the victim in this case, that's the direction I think defense counsel was going. And I think that it's important to keep that in mind. They weren't extra assault and battery charges or assault and battery with a dangerous weapon charges. There's very specific elements of the Commonwealth that needs to prove beyond a reasonable doubt to prove strangulation. And I think that that's what, and again, I certainly wasn't in the jury room, I think that's what was happening here as opposed to we're splitting the baby, if you will. As far as the second issue is concerned, Your Honor, it's also concerning that the defendant was not allowed to cross-examine the victim about what I would consider truly important line of cross-examination. The witness's truthfulness was going to be called into question by defense counsel. The witness, as the court knows, had previously sought a continuance for some sort of medical reason. There are trial counsel indicated to the court that he had photographs. I believe he said they were off of Facebook or Instagram, some social media post that my kids know about.
But he had no intention of putting in evidence or attempt to make an exhibit, right?
I'm sorry, Your Honor.
He had. My question relates to whether he even had a foundation for any of this. And his investigator saw posts on Facebook.
And I think he was going to ask the witness about that.
Right, but how do we don't even know that she misrepresented anything. Maybe her medical procedure was in Florida, if she was there at all.
I think that, again, from the black and white pages of the transcript, it appears as if trial counsel had information that she was in Florida for at least ostensibly a non-medical purpose. I'm completely with
you. That's what he represented. But what I'm saying is, what did he establish? How do we know that the Facebook posting that he's talking about showed, I mean, maybe she was somewhere else rather than Florida? Is she standing next to some Floridian landmark or something that would indicate?
Wasn't sure where you're going with that, Your Honor. So, so from the record, and again, without getting into what I know that isn't on the record, from the record, I think it's pretty scant.
But it's entirely collateral to what the case was about.
So respectfully, I disagree with that, because if the case revolves around the credibility of the victim versus the defendant in a self-defense case, that I would respectfully suggest that any specific evidence that trial counsel has that goes to impugn the credibility of the victim does become important in this particular set of facts.
Mr. Crane tells us in his brief that Section 608 of the Evidence Guide said this is a singular instance of misconduct to show untruthfulness, and that's not admissible.
I disagree.
Well,
I agree that it says that in the brief.
SJC says in Bosch from 1982 that the judge can limit impeachment when the testimony concerns a collateral issue.
But again, yes, absolutely. The question, I think, then becomes whether or not this is a collateral issue. But I don't believe it's a collateral issue. I believe that the victim's testimony
he's on trial for assault and battery, right, on her?
Correct.
And you don't think it's collateral that she may or may not have had a medical appointment in Florida at some point?
It's not an issue. The issue is whether or not she had a medical issue in Florida. The issue, quite candidly, Your Honor, is whether or not she the word perjury is strong, but nevertheless, the court was informed that a continuance is needed by the Commonwealth because the victim in this case was seeking medical treatment. Defense counsel had in his possession what appears to be information that challenges that.
Why? Hang on, why? Because she was in Florida on the same day?
It appears that way.
Yeah, but what if that's true? What if she had a medical appointment in the morning and took a flight to Florida right after her medical appointment? So why can't she be in Florida in the afternoon?
She certainly can't.
Just because she's in Florida doesn't suggest she's lying about her medical appointment.
And this is where it gets not troubling, this is where it gets difficult, Your Honor, because again, I think that the record could be a heck of a lot clearer as to what it was that defense counsel had.
That goes back to my original question, that defense counsel didn't have enough here. I mean, in addition to what Justice Desmond just said, she could have had a medical appointment in Florida. I think we can take judicial notice that there are doctors in Florida.
Absolutely. Absolutely. Again, because I'm bound by the record, it's difficult to convey.
As are we.
I'm sorry.
As are we. We're bound by the record.
Of course, Your Honor, of course, Your
The
Honor.
record does not tell us, or the judge, which more importantly, the trial judge doesn't tell the trial judge that she wasn't in Florida for a medical appointment.
Correct. I agree with Your Honors. I absolutely
So
do.
you're conceding that we can treat this issue as waived?
I would never concede that you can treat an issue as waived, Your Honor. It's not squishy in any way, shape, or form. Apparently, I'm going to use that word all day now, Justice Blake.
Great word.
It's a great word, a very legal word, Your Honor, and I appreciate it. Regardless, I do think the first issue that I've briefed in this particular matter is certainly the one that I think the court should pay the most attention to without waiving the second argument in any way, shape, or form. And if there are no further questions, I'll rest on my brief.
Thank you, Mr. Crane.
Thank you very much, Your Honors.
Mr. Crane, welcome back.
Good to be back. May it please the court, Jesse Crane for the Commonwealth. I'll just briefly start with the second issue. I think the discussion that was just had regarding what the victim may or may have not done in March of 2022 explains why this was not a piece of evidence that needed to come in. It was a collateral issue. It would have required an extended discussion of what exactly these photos were, where they're from, when they were taken, when they were posted. I think the trial judge correctly barred trial counsel for the defendant from attempting to impeach the victim on that point. And then turning to the first issue, the defendant's continuance, I think when looking at the sum total of factors that the trial judge was looking at when deciding the continuance, it was clear that he correctly exercised his discretion. Multiple important witnesses were already present. The victim, the defendant, and 2 law enforcement witnesses were in the courtroom. A jury was about to be impaneled. And defense counsel was representing really only that Mr. Guarino was going to testify to these 4 specific wounds that...
The counsel was adamant that he wanted a live witness. And I think you'll agree that a live witness is always better than a stipulation.
I think in some circumstances, and maybe even in most circumstances, yes. In this situation, I think where it was unclear that Mr. Guarino was particularly interested in cooperating, and it didn't seem like defense counsel was positive even as to what the content of what he would testify to. The defendant came out ahead in terms of the stipulation because he didn't have to put a witness on the stand that he was uncertain what he would say on direct or cross.
Do we know if the investigator for the defense had ever met with the witness prior to that knocking on the door and learning that he had COVID? I mean, had the witness ever told the investigator what he observed? What were the injuries that he actually saw?
We don't know. It's not in the record. If the panel has any further questions on either issue, I'd be happy to address them, but if not, I will rest on my brief.
Thank you both.
Thank you.
We'll do the sword case, yeah, but he's out in the hallway. AJ, can you get Mr. Stiles in the hallway? We're going to call the next case. Mr. Stiles is in the hallway. We move quickly, Mr. Stiles.
Thank you, Your Honor.
The next case is 22P565, John Doe 322724 versus the Sex Offender Registry Board. Mr. Stiles.
Thank you very much, Your Honor, and good morning, Justices. I'm Ethan Stiles, and I'm here on behalf of John Doe, who is with me in the courtroom today. And we are here under unusual circumstances because what we had originally argued in the brief had morphed due to circumstances into something else, and thus we are here to ask for relief that is of a more serious, more fundamental character than was originally requested in the brief.
So, Mr. Stiles, this is what you do for a living.
Yes.
You're here all the time. Let's assume I agree with you that this is highly problematic.
Yes.
I know one of the things you suggest is that we can say he's a level 2 and that will be the end of it. Let's assume I don't agree with you on that. And let's assume I think he potentially is entitled to a new classification hearing. What's my path? How do I get there? Because this is procedurally a nightmare, right? The Superior Court, this all happened after the Superior Court judge had ruled and the appeal had been filed here. And so the Superior Court judge hasn't sort of weighed in at all on this new report. So is it a remand to the Superior Court to order a remand to the board? Do you see what I'm saying?
Yes, Your Honor. Normally, in a normal situation, I think the court normally says if they agree with the petitioner, they say, remand for further proceedings not inconsistent with this opinion or words to that effect. And usually in those situations, it usually goes directly back to the board because the Superior Court is pretty much like an inferior appellate court in this situation. And therefore, your decision, you've heard the case, you've heard the merits, trumps it, and it goes back to the board, and he has a new hearing, new counsel is appointed, and, he gets a new decision. That's a normal process. I mean, I don't see the Superior Court as being anything more than, a procedural matter, but if it has to go that way, then it simply goes that way, and it simply takes a little longer.
I've looked at other 38 cases, and I haven't seen anything procedurally like this. And you're the SORB guy, right? You do these cases day in and day out. I'm assuming that you haven't seen something like this in terms of procedurally what the remedy is. I know you talk about egregious misconduct, but again, if we put that aside for a moment and just how do we get him to get a new hearing?
I would say, if we put aside for the moment the egregious matter and just consider the original claim of error, that the board's decision was unfounded, it was contrary, it was arbitrary, it doesn't make sense.
First decision.
The first decision, right? Because the amended decision, that comes in pretty much only to the egregious point, but the original decision, it's flawed. Both parties have agreed, at least at some point in time, that it's flawed. It needs to go back. So I believe the normal procedure in these cases is the court issues its order and I think the board just takes it and gives them a new hearing.
That's what you're requesting?
I'm sorry?
That's what you want? Is that
That's what we wanted in the beginning. And obviously that's an option, that's an option the court could consider, but I would think that under these circumstances, the court has the obligation to do more given what has occurred in this appeal.
More like what?
Essentially, because of the egregious misconduct, the sanction that we've requested, essentially that it order a level 2, is fair and reasonable in this case.
How so? I mean, that's awarding your client for misconduct of the sort, but speaks nothing to his conduct and what the purpose of the classification is, which is to protect everyday people.
Well, the classification purpose is to ensure the rights of both the public and the offender, and here the offender's rights have been violated in a rather egregious form because—
I understand. So a new hearing fixes that, right? Not making him a level 2.
Well, under these circumstances, it's hard to see because it looks as though the SORB is prepared to do whatever it takes to get him a 3. That
may be true, but that's an issue for SORB.
Yes,
and talking about how he gets a level 2 because SORB feels so strongly that he's a level 3. I mean, and would do anything, according to your words, to give him a level 3.
Well, I think this court has to use its rare power to step in and say that in this case, the situation that so far has been so unfair that we can't see how he can get a fair hearing under these circumstances.
Mr. Stiles, was it unfair, or did the left hand not know what the right hand was doing? And that you should get the benefit of the bargain that was struck, and that's a new hearing?
Well, I mean, in this case, the left hand certainly should have realized that what it was doing was improper and unfair, in violation of what was brought down. So I think that it's ultimately this, he has to go before the SOAR. I mean, the SOAR has both its litigation arm and it has its hearing arm, and it's all in a black box wherever the SOAR lies to what goes on behind the closed doors. And you know,
Counsel and for both parties realizes that there's procedural improprieties in the decision, and the hearing officer doesn't understand that, we'll suppose, and she thinks that instead it just needs to be corrected, the errors need to be corrected. I mean, he didn't get what he bargained for, but I'm having trouble with egregious misconduct.
well, I mean, essentially, when my sister's predecessor approached me, you know, he said that that there would be, you know, there was major flaws or serious flaws in the decision, and that it had to go, and that they offered it to go back for a new hearing. That was our understanding, and I said, yes, okay, you know, we agreed on a stipulation, and we filed it. Now, before that stipulation could be acted upon, the very next day after we filed it, we get this new decision. That essentially does nothing but simply try to fix whatever problems the hearing examiner thought.
You wouldn't have signed the stip if you knew that was coming.
Absolutely not. I would have held them to the original decision, and we're arguing that today.
Hypothetically, if the hearing examiner had endeavored to correct what I would say is sort of ministerial, clerical type errors and hadn't changed moderate and high, would we be in the same situation?
It would depend upon the nature of the corrections. I would suggest the number of instances in this decision that where the language was implicated strikes to me at the very least a carelessness that is not congruent with this court's and the SJC's court's decisions that require a careful attention to the evidence.
Did you represent Doe in the Superior Court?
I did not.
Okay. So I don't remember what we have in the record. Did his lawyer in the Superior Court raise the issue of the moderate high and the internal inconsistency in the report before the Superior Court judge?
He did not.
Let me ask you this question. Let's assume, for the sake of discussion, that SORB didn't go back and amend the decision, and there was a hearing on the first claim. That is, they say moderate, and somehow their math equals high at the end. And we had an appeal on that issue, and you prevailed. What would your remedy be?
Let's see. So if I understand you correctly, Justice Desmond, if after this hypothetical rehearing, the hearing examiner held that the aggravating factors were high, she was entirely consistent in her findings. Is that it?
I'm sorry. The original decision, she starts the paragraph by saying he's a moderate, and then at the end of the paragraph, she finds that he's a high, right? That happens on a few occasions in the original decision.
Yes.
And you appeal that.
Yes.
And you win. What would your relief be?
At that point, the relief would be a new hearing.
Okay.
And of
So
course,
why
the
don't
length
you
of
get more than that now?
yes. You know, obviously, at that point, you know, the new hearing, we could argue if there were additional factors. I mean, for example, at the time of the original hearing, he was still in custody, he was still in prison, but he had been released. He had, you know, if he had done well for himself, we could argue that the hearing examiner's qualified weight given to the stability factors, the community stability factors. You know, should we get full weight now if he shows that he can behave outside of prison? And obviously argue some other things more strongly, perhaps the actuarial evidence and the studies. But obviously, that would be a different animal than what we have here today. Now,
I'm sorry to interrupt. Isn't there a procedural problem having raised this for the first time in a reply brief?
well, it's obviously that we have to go under the substantial risk of miscarriage of justice factor. So the extent, you know, obviously the waiver is what you're talking about. But I would suggest that this does rise to a substantial risk.
It's more of a pure form of waiver that we don't have to address claims raised for the first time in a reply brief.
Well, I mean, normally, but in this situation, the scope of the landscape is so changed, that I think you are compelled to under these circumstances. I respectfully submit that, because obviously we have here a decision that my client was essentially sandbagged by the board. I mean,
There was some gross unfairness here, don't get me wrong. I'm just trying to figure out, I think this is where Justice Blake started, and it's the path we need to follow to getting to a remedy.
well, I really hope that the court's path is fairer than the board's path is, because, this is a situation where there was a case a Supreme Court case which says essentially a promise by a government attorney binds the government. And that case is Giglio versus United States. It's 405 U.S. 150, a 1972 case. And normally we see these cases more in the prosecutorial bent, but still, if this sort of behavior is allowed, then what is the difference between the board and the prosecutor's office? I mean, essentially, as my predecessor said, if we don't follow fair procedures, it's prosecution. It's not impartial classification anymore.
Well, it is an administrative proceeding, albeit one that affects Mr. Doe's liberty.
Yeah. Yes, and he does have substantial rights at play here, and if they are...
I have some specific questions that, just in
go
view
ahead.
of the time, I'd like to just ask you. The board suggested that your client could have sought a reclassification hearing in August of 2023. My understanding is that while this is on appeal, you cannot seek a reclassification. Is that right?
That is correct under the board's regulations.
And is it also true that as a result of the new decision, and let's assume there was no appeal pending, because there was a new decision, that then bumped the reclassification date from 2023 to 2025?
Well, Your Honor, that's a good question, because I did have a conversation with someone from the SORB about that, and they said, no, we're not going to consider. They're not going to consider that. So I have that in writing that says
Not going to consider
that the amended or the revised decision's date is the controlling date for his reclassification. They said
Now we're in 2024, though, so I'm assuming a reclass didn't happen last year.
it did not. And the reason for that, although it was my sister did offer it back in July, essentially offering a de novo hearing before a new hearing officer, that was 6 months, that was months after they filed their briefs and their motions upholding what they did. So at that point, my client really can't trust that he's going to get a fair shake before this entity.
Are you familiar with the CMR that addresses the board's ability to correct errors in decisions?
I've read it, yes.
I'm sorry?
Yes, I've read it.
So 803 CMR 1.21.
Yes.
Okay. What should the hearing examiner have done under this regulation, as you understand it?
Well, given the circumstances of the case coming back to her, she should have ordered the new hearing, set a date, appoint new counsel because because I'm not qualified at the hearing level, or I may even taken it myself. I might have that authority, but essentially, yeah, she should have taken the she had taken the case and ordered a new hearing and allowed the parties to submit whatever materials they wanted to submit, and just
Basically a redo.
a redo, yes. But that
If we send it back, does the hearing officer get to consider what's happened from the time of the second report to today, essentially?
yes, absolutely, because
You're asking us to send it back to a different hearing examiner.
as the alternative, yes. Because I think that this hearing examiner obviously just didn't understand and very well could be biased against my client, given the circumstances of a second remand. But anyway, I think the first decision is appropriate, given that the board initially defended this and actually tried to uphold the stipulation of dismissal, but that was not allowed by the single justice. So under these circumstances, we should really consider whether the board has truly acted in the best interests of both the public and as well as my client in protecting the rights and ensuring that there is an impartial administration.
Let's assume we say that they didn't act in that way. Where does that leave us?
Well, that leaves us to decide whether the board's conduct was so egregious as to require the sanction that is requested,
Which is what, level 2?
Level 2, or to remand it
See how
back.
those two things are tied, are linked together. Maybe it's me. So help me understand how he's deserving of a level 2 based on the misconduct of the board notwithstanding the facts and circumstances and the factors that we have to consider with respect to his classification?
Well, I mean, I've laid out in my brief, in reply brief, that a level 2 classification is not without the bounds of reason, given the state of the evidence below, and that in this particular case, the circumstances are so questionable as to whether there is an institutional bias against my client that compels the sanction so that he starts and continues at the 2, and he doesn't have to be worried that, that the next hearing examiner, friends of the previous one, in a closely working environment is going to do the same thing. So I think that in this situation, if the court requires an imposition of a level 2, that's his baseline going forward. And I think that is appropriate given what was occurred in this case. And if there are no further questions,
Thank you.
I thank you for your time.
Ms. Lamano.
Thank you. Good morning. May it please the Court, Gabrielle Lamano on behalf of the Board. As this Court is aware, it's well established that administrative agencies have inherent authority to reconsider a decision.
They do, but how is it fair when you enter into an agreement with Mr. Doe that you're not going to do that? Instead, you're going to vacate his classification as a level 3 and send it back for a new hearing. And instead, you come out with a new decision that fixes some of the mistakes. How is that fair?
So with respect to the representation made, I think we would be in a different position if the stipulation of dismissal had actually entered and the appeal had ceased. Now,
you both agreed to it, right? You
Correct.
signed it? Was it you or someone else?
no, it was the predecessor.
Okay, so is it the left hand doesn't know what the right hand is doing here?
That's what it appears. But I think, again, I
So
think
why shouldn't you be held to the stipulation that was signed by someone authorized by the board to sign that and vacate his level 3 classification and give him a new hearing?
Sure. So I think for 2 reasons. The first reason is if you think of sort of a collateral estoppel, a reliance issue here, while Doe may have relied on that representation by the board, again, the appeal was not dismissed. He filed a motion to reinstate, which was allowed.
It was not dismissed because how shortly after that does the hearing examiner put in the revised decision? And then you all say, though, all bets are off, we've got a new decision. Sorry, Mr. Doe.
Correct. But again, that did not occur here. And then I think
Go ahead, I'm sorry, answer the question.
that's okay, thank you. The other point I was going to make is that while
Before we move to another point, what occurred here was that they pointed out the flaws in the decision, right? And then somehow Thorpe says, oh, we discovered some flaws in the decision in their Scrivener errors, which I have a hard time accepting, not only because we just changed the word from moderate to high, but we add a new paragraph to the decision, which doesn't strike me as a Scrivener's error, and then say, hey, well, no harm, no foul. I mean, I haven't heard the direct answer to Judge Mead's question, which is, how is it fundamentally fair to Doe?
I don't think it's fundamentally unfair because his
How is
classification.
it fundamentally fair?
His classification did not change. It would be maybe a different scenario if he went from a level 2 and this new decision made him a level 3.
You promised to vacate the level 3. So if you had kept your promise, then his status would have changed. And he would have had a chance at a new hearing to achieve his goal of perhaps being a level 2.
That may be true, but again, his level didn't change. And I think another important point is that there was nothing.
If the stipulation had been honored, and in this circumstance, you're the government, right?
Correct.
The government needs to be held to the bargains that it pitches, right?
Correct, and I agree that it was an unfortunate circumstance, especially the timing. And perhaps it may have been a better alternative or a better course of action for the board to remand this and give him a new hearing.
And a better course of action would have been for the board to agree that this revised decision was inappropriate given the stipulation that had been brought about.
Correct. But I think it's worth mentioning that there was nothing raised, there was nothing in the first decision or nothing raised by the offender about anything that was wrong or anything that took place with respect to the hearing that was unfair to him. He was given the opportunity to have a hearing. He testified at that hearing. He presented evidence in that hearing. His procedural due process rights were protected by that, and there's
If we had stopped right there, I would agree with you. And then Mr. Chennai and Mr. Stiles enter into a stipulation, and time just moved quicker than I've ever seen in a court case, where it gets submitted, our clerk's office doesn't have a second to process it, and a new decision comes down. This is a due process issue for me. I'm not looking to shoot the messenger, but a message needs to be sent to your hearing examiners. I appreciate someone standing up and saying, you know what, my report was an error and I made mistakes, but not at his expense. Look, this was a horrendous rape. Maybe he is a level 3 and should be forever. I don't know. But he's entitled to a hearing and a fair hearing, and he didn't get that. Full stop. So what I want to know from you is, how do we fix this? If I want to send it back, and I have no idea what my colleagues want to do, but I'll tell you right now, I can't live with this decision. If I want to remand it, how do I do it?
So Your Honor raised an interesting question to Attorney Stiles, and I don't know exactly the answer to that either procedurally. I think this court could enter an order vacating the amended decision and sending it back to the board for a new hearing, and also vacating the order of the Superior Court upholding the original decision. Since that decision is no longer in effect, I don't know that that's even required, but I think this court could fashion an order. I also wanted to answer Your Honor's question that was posed to Attorney Stiles in terms of his eligibility for reclassification. So the regulations don't provide exactly an answer to this. It's sort of a gray area. It is something that's going to be changed in the updated regulations when they are.
Has SORB taken the position that final means once the appeal is concluded?
So what SORB's position is that final is the final decision that's issued after a classification hearing. So in this case, that would be the original decision that was issued in August of 2020. So from SORB's perspective, he was eligible for a reclassification in August of 2023. And that's what was represented to Attorney Stiles. And it's not, I recognize it's not in the record, but we did have conversations with Attorney Stiles about that we would allow him to seek reclassification in August of 2023. Your Honor is correct that there is a provision in the regulations that while a case is on appeal, if an offender moves for reclassification, the board may summarily deny that. But I think given the circumstances of this case, I can't say definitively that the board would not deny his request for that reason. But I think given that myself and my supervisors had conversations about initiating that reclassification hearing, I don't think we would then turn around and say we're denying it because there was an appeal pending.
Doesn't the CMR prevent exactly what happened here, 803 1.21? There's a process to be able to correct a decision. And this was more than typos and clerical and ministerial. And I know you argue Mo. I'm going to tell you right up front, I don't think this case is moot. He didn't get what, Mo got the relief that Mo was looking for. Doe did not. So assume it's not moot. I look at the rest of Mo to talk about when an administrative agency can reconsider their decisions, but you have to read that in connection with what your own CMR says. I just hope that there's some, again, I know I'm shooting the messenger, but some kind of training for your hearing examiners. This should never happen again. And I know that we didn't act on the stip, but a lawyer's word is their bond. We had 2 lawyers sign a document that was submitted to a court. To me, that's tantamount to a court order. So I feel strongly that message be taken back to SORB.
I understand.
And not defended. And not defended. I mean, it seems to me that one might arguably think that they don't see the impropriety of what took place here today. And it's sad, I'll say. I mean, this is a case where we're supposed to be trying to have integrity and do justice, you know? And he points out the flaws in the case, and you concede the flaws, which I thought was stand up, but make an agreement with him, okay? But then you go and you find what you think is a loophole, arguable loophole, and say, well, you know, we have this inherent authority to go back and amend our decision. Now that you've pointed out all the flaws that may be persuasive we're going to use that authority to go back and fix them and say, oh, too bad, so sad for you. And there's something that just smells foul. I mean, I can't fault co-counsel or counsel for Doe to say he feels like he was sandbagged. I mean, I get it. I get it. And it's unfortunate because SORB has an important responsibility. And they need to be cloaked in the integrity and the honor that they have assigned to them. And I just don't see it in this case, unfortunately. No question.
Do you have a position on our ability to enter a level 2 classification?
Yes, I do. So I think as Justice Desmond pointed out, I don't think that that's an appropriate remedy here in this case. I don't think that what happened gets us to that. I think that that argument is predicated on the idea that SORB seeks to classify every single offender as a level 3 offender, and that lowering a level 3 to a level 2 in some way punishes the board. And that's just simply not the case. As Justice Desmond properly pointed out, our job here is to balance the rights of an offender, but also balance the public safety interest here. And a hearing examiner, the case law has said, and the regulations say, is in the best position to assess that. They're in the best position to assess the evidence presented and to make conclusions about what that evidence dictates.
Do we even procedurally have the ability to do it if we could?
That's a good question. I'm not sure.
It's rolling with the good ones today.
But again, I don't think that that's appropriate here. And I think that could create a risk to the public safety. I think that if the court, as it's already indicated to me, and I hear the message, that the court believes that what took place was improper. I think the proper remedy here is to send it back to the board to order a new hearing, which, as I indicated, he's already eligible for at this point. And time has transpired since his hearing in 2020. So he would have the ability to present new evidence, perhaps more mitigating evidence, given the amount of time that's taken place, given the fact that he's been he hasn't been incarcerated since the last hearing. It's likely that he would have some further mitigating evidence to present than at the time of the last hearing. And that would be the proper remedy in this case if the court does believe that what took place was improper.
Thank you. Well argued, Mr. Stiles. Ms. Lamano, thank you for being the messenger with such elegance and poise.
Thank you very much.
With that, we're going to take a recess. But thank you.
All rise. What is in recess?
Our next case is 23P40775 Arlington Street versus Strathmore Insurance Company. Mr. Levine.
Thank you, Your Honors. Good morning. My name is Michael Levine. I represent 75 Arlington Street, Inc., referred to them and others collectively as Davios and Davios Steakhouses. Fundamentally, courts must accept well-pled allegations. They are not permitted to disregard the allegations simply because they may be improbable or that the court may be skeptical of them. Whether the allegations can be substantiated is a matter for evidence and a matter to be determined after discovery. Justice Blake, to your point, it may be that the allegations can't be substantiated, but that does not mean that the party pleading them is not entitled to their due process, their opportunity to establish those allegations, your point in the last case. Likewise, as practitioners, we are guided by the teachings of the high courts under which we're practicing. Here, the SJC, Supreme Judicial Court, and its teachings in the Vervine case. And Davios pled its First Amendment complaint consistent with the teachings of the SJC in Vervine. Now, Vervine sets the framework for the claim that Davios brought here. What's necessary to successfully plead a claim for physical loss or damage under a first-party insurance policy.
I think we understand the argument, which is essentially you're going to say that the virus somehow penetrated the material property such that it was a demonstrable loss of property or words to that effect. I mean, essentially, you take it, you see what Vervine says, and then you say, okay, we're going to shore that up. And instead of just talking about the effervescent part of it, we're going to talk about how it actually seeps into the materials and infects the materials such that they can't be used for their intended use.
So, Justice Desmond, I think you just articulated exactly what the evidence would show, right? I mean, that's sort of skipping ahead and getting to what would be proven ultimately at trial. But for pleadings, because this case was dismissed on a motion to dismiss, Judge Salinger allowed the motion, we're talking about what's necessary to plead the framework so that we can then adduce the facts and the evidence and the expert opinions
It's got to be,
prove.
your briefs uses the word robust more than a few times to discuss the allegations, but they can be read as conclusions when I looked at them. So what is the actual distinct physical damage or alteration that was caused to Davios because of the virus?
So again, a matter of evidence. And I'm making this point for a second time because it's so critically important in assessing a case on a motion to dismiss on the pleadings versus
I understand
at
that, but could you answer my question?
Sure. Taking, of course, the fact that we haven't had discovery, there are no facts and no evidence to go on.
What's the distinct physical damage or alteration the virus caused to Davios?
The damage and alteration that was caused by the virus was the danger that it posed as a consequence of being at the restaurants that rendered them unsafe for use.
What property are you referring to?
The restaurants themselves. So each of Davios' restaurants, because it was infiltrated with the dangerous substance, was rendered dangerous and unfit to a point that it constitutes or rises to the level of physical damage. We'll talk about loss separately.
I mean, did the restaurant get thrown away?
No, it did not. And the First Circuit has very similar questions in the Legal Seafoods case. It didn't experience a fire, the tables weren't smashed, the roof wasn't blown off. All of those instances would be covered damage, but that's different.
And Lawrence General Hospital, too, that was decided last week, right?
Right.
So the other courts that have addressed this have failed to see the physical essence or the actual alteration caused by the virus.
Well, again, for the third point, and respectfully, Your Honor, we're talking now about evidence and what would be proven. Now, Lawrence General took Vervine and went way too far. It said things, at least three, and I'll articulate them for the court, that Vervine never said. It took the standard, and, to be colloquial, it feels like a game of whack-a-mole, because the SJC laid out the framework, 4 essential elements distilled by the First Circuit in Legal Seafoods and SAS, and then Lawrence General comes along and took that and expanded it far beyond what Verveen ever said. And it's the 4 elements from Verveen that Davios was instructed to plead its complaint by, which it did. It articulates in its complaint in very robust detail the 4 essential elements as spelled out in Verveen, distilled by legal. And those are simply a distinct, demonstrable, tangible alteration requiring active repair or remediation.
But beyond the labels, though, you have to have pled facts that would entitle you, or plausibly entitle you, to some relief. And I just keep hearing the conclusions.
So if Your Honor would allow me, I'll direct you directly to the allegations on each of these elements. So on the distinct, demonstrable, tangible alteration element, in the first amended complaint, this is at Record Appendix 48, paragraph 73, paragraph 74, and paragraph 76A, specifically talk about how the presence of the virus caused a distinct, demonstrable, tangible alteration to the property. Of course, again, allegations, not evidence. The evidence would come later. The second element.
No. What were they? What was the physical damage and alteration that was caused by the virus? Not just the bald statement.
Simply stated, it was taking the property in a safe and fully functional condition, introducing a dangerous substance that rendered that property unsafe and unusable as it was before the introduction.
How is that physical?
Well, under the broad all-risk first-party policy that we're dealing with here, historically, and I can cite the cases that were discussed in Lawrence General and others, but when it doesn't just require the roof being blown off or the tables being smashed. If you have a dangerous substance that infiltrates property that renders it unusable.
There's got to be a corporal component to it, though, right?
I'm sorry?
There has to be a corporal component.
There has to be a physical presence of something, whether it's fire or a
It has
invisible.
to be a physical damage.
Well, that's the question. That's the legal, right?
Yeah,
I mean,
I know.
that's the
I'm trying to get
million-dollar
there.
question, right? What is damage? Now, we can agree the damage is smash the table, blow the roof off.
Right.
Right?
Those are
But-
easy.
But damage, and again, historically, look at the 60 years of case law. It doesn't require that level of smashing or blowing the roof off. It can be other forms, and it can be as benign as odors and noxious substances that render something
it's
unsafe.
undeniable that the business suffered, as did just about everything during the pandemic. But it has to be tied to the component language in the policy itself in order to be covered.
Agreed.
So, alien space invaders could have ruined Davios's business too, but that wouldn't be covered.
Well,
right?
it depends what the alien space invaders do, right?
They sent green vapors into the restaurant.
Well, I
But
think,
it
Your
caused no
Honor,
physical damage or alteration.
I think Your Honor's touching on what the key issue here is, right? It's
The alien
what-
part or
No, it's what the aliens do, right? Merely being present isn't enough. They may be guests having dinner. That's not damage. But if they come in and are emitting a deadly gas or other substance, now we may have damage. Again,
No.
and I'm not saying do, but may.
Well, if they come and they're admitting a deadly gas and they're asked to leave and they leave, how has Davios had any lasting property damage?
Well, I think you, again, are hitting on one of the key points. If it's as simple as you can pick it up and throw it out and it's gone and done,
Well, you can
again,
clean it. I mean, it takes a
may
little,
not be
it takes a little bit more cleaning than you might want to do, but nevertheless, it can be clean. You're not throwing the ovens away, you're not throwing the tables away, you're not pulling up the rugs and throwing the rugs away. I haven't been to Davios, they may not have rugs, but whatever it is, you're not taking all the pictures off the walls and throwing them away. All that stuff remains in place.
but it's a matter of degree. And that's exactly what it comes down to. It's not always, it's not this presence equals damage. I would agree with Mr. Varga and the insurance company, that's not sufficient. But when the presence causes such a danger that the property cannot be used, whether it's blowing the roof off or simply creating a deadly situation, then that is damage, and it has been for 65 years.
So the insurer in Vervain is the same insurer that we have here, yes?
That's correct.
Do we know if it's the same policy? Is it the same language?
I have not compared the policies. The core language, the physical loss or damage language is the same. There were other very critical differences, however. For example, the policy in Vervain had an explicit virus exclusion. And that was very important in that case because...
That's not the case here.
That is not the case here.
Is that what the SJC relied on?
It did not rely on it, but it did note it, and here's the critical importance. The allegations in Vervain focused on the government orders. They could not say that the virus was present and that the virus damaged the property, because if they did, they would have pled right into the exclusion. So it's a very different case, and that is one of the key points here. This policy covers presence and damage caused by virus. That policy did not. And it also begs the question, Justice Blake, why would you have such an exclusion in an insurance policy if a virus wasn't capable of causing physical loss or damage?
Well, if I asked you, similar to, as Justice Desmond said, you're not necessarily throwing out tables and restaurant equipment, are the damages, I mean, obviously there are lost profits, but are you suggesting that the damages are the cleaning and the remediation?
So there are two types of damages, if you will. One is the business income damage, which is the loss of profits. The other component is called extra expense. It's the additional amounts that are required to be spent to deal with the damage.
And
so it's
Strathmore paid zero on this claim?
Zero.
As to both types of damages?
As to both types of damages.
Doesn't Vervain caution us about finding a negative implication because one policy has the virus protection and the other policy does not? I think even in Vervain, I think Little Donkey had the virus, but Copa and Toro did not. And I think they explicitly say, we're not saying that because they don't have it means that it's not covered. Or I think you get the gist of my question. I might have got a little tangled there. But isn't that what you're asking us to do?
No, it's not, Your Honor. And if you look at our briefing, we did not make that. That's not the force of our argument. I raise it because the question came up about Vervain, and I'm trying to illustrate the difference in the pleading and why that case was pled the way it was. That I would be very grateful if the court were to read into that what I feel is the fair implication. Again, why would you have it if it's meaningless, which is essentially what the insurance companies are saying. But that's not the issue here. The issue here...
Specifically not to do that.
I think they caution, right? But we can agree that's not the focus of our argument here. The argument here is Vervain laid out the standard. The pleading in this case met the standard, and Judge Salinger did not even apply the standard, because if you look at his order allowing the motion to dismiss, he focuses on the wrong part of Vervain. And this is at record 450, I believe. Judge Salinger says, the facts alleged in the First Amendment complaint do not plausibly suggest that plaintiffs suffered a direct physical deprivation of the possession of their restaurant premises. That's not the standard for damage. That is the standard for physical loss. And these policies cover both.
We're reviewing de novo, though, right?
Right.
Yeah.
What jurisdictions have agreed with your argument?
Several, Your Honor, and depending at what level.
Are they beyond trial court decisions?
They are, yes, they are. And most recently, and I'll point this out, I wasn't going to talk about other jurisdictions, but since you ask, I will. In Washington State, the Hill and Stout decision, Washington Supreme Court came down some time ago supporting the insurance company's position. Just a couple of weeks ago, the University of Washington's case, that motion to dismiss, was denied, recognizing the difference, and it's the difference that we're arguing here, that there are some cases and some sets of facts that just don't get there. They don't meet the standard and never can. However, there are others that merit evidence and proof because they may. Now, the Baylor College of Medicine case is a great example in Texas. And this case was tried to a jury. And the jury heard the evidence, and they heard from the experts, and they found in favor of the policyholder. And they awarded $45 million. Now, that case is on appeal, but it's an illustration of what the evidence can show if the evidence is allowed. And that's all we're asking for here. The
Was there
SJC,
anything in the amicus brief that you thought was helpful to your argument?
everything. Yes, the amicus does a very good job talking about the historical perspective. I've referenced the 65 years of precedent, and they do a very nice job talking about that. But I think the real issue here is not 65 years. It's a good background. It provides good color. But what really matters is what the SJC said and what Davios pled. And if those line up, the case should be allowed to proceed.
Okay.
We're not contradicting
hold
the
you there,
SJC.
Mr.
We're
Levine.
embracing it.
Thank you very much.
Thank you.
Mr. Varga.
Good morning, Your Honors. May it please the Court. Gregory Varga from the firm of Robinson & Cole, representing Strathmore Insurance Company. With me is my partner, Jonathan Small, at counsel table.
All of Strathmore's policies going forward all have virus exclusion clauses in them?
No, they don't, Your Honor.
Why not?
Oh, going forward? Good question. I'd have to check on that. I thought you meant did all of them that were issued. No. Let me begin with this. I think the reason why Mr. Levine had such difficulty answering the question is because there is no answer to that question. The SJC said in Verveen, the question is not whether COVID virus is physical. They said whether the issue is whether it has a direct physical effect on property that can fairly be described as loss or damage. Across the country, plaintiffs have tried to plead something that constitutes what all of us would consider physical damage. They've failed. It happened in the Verveen case. It happened in the Legal Seafoods case, where Mr. Levine and I squared off before the First Circuit. It happened in a number of other cases at the First Circuit. They tried, and I can show the Court a copy of the Lawrence General Hospital complaint, which is 95 pages, 260 some odd paragraphs of allegations, including what purport to be scientific allegations of what virus does and how it behaves inside a building, presented by an MIT virologist.
Did anyone argue any Rule 8 problems with that?
That's a good question. I didn't review the papers closely enough for that, Your Honor. But here's the point. Despite all of those allegations, which are far more substantial and detailed and scientific than what was pled here, the First Circuit correctly said, Verveen controls. Simple as that. And they affirmed. But let's talk about here. Let me answer the question, if I may, that you asked Mr. Levine. But I'm going to answer the negative. Why haven't they pled distinct, demonstrable, physical alteration of property? And I would take the Court back to the very same paragraphs that Mr. Levine highlighted for you. If you look at paragraph 73 of the complaint, what they talk about is how virus allegedly alters the air. And what they say is virus particles physically damage the...
What's the record site?
The record site, Your Honor, bear with me one second. Paragraph 73 appears at record 48, RA 48, and 49. Those two pages are the paragraphs that I'll direct the Court to. Thank you. What they say is that it damages the indoor air because it introduces, quote, highly infectious physical substances into the air. All right, paragraph 76. Virus changes, alters, and transforms the content of indoor air such that the air, quote, now contains a concentration of SARS-CoV-2 infectious particles. Paragraph 76B. The presence of COVID virus makes restaurants unfit for their insured use for in-restaurant guest dining. And paragraph 78, facilities remain at high risk for spreading COVID-19 among staff and guests. What are they talking about? COVID-19 affects us, humans. It doesn't do physical harm of the kind that the SJC had in mind to this lectern, to spoons or plates or glass or drapes or tables or chairs or anything else that constitutes the kind of property that our client insured. So they have not been able to articulate, for example, a way in which that that COVID virus or any other virus harms physically some object. They don't allege that it causes corrosion or rust, that it burns it, that it soaks it and warps it, because they can't.
Like the ammonia or gasoline case.
Absolutely, Your Honor. Those cases, the SJC put in its opinion in Verveen. That is the Western Fire Insurance versus First Presbyterian Church out of Colorado, the Farmers Insurance versus Tritanic out of Oregon, and the Gregory Packaging case out of New Jersey. The SJC put those cases in that opinion to set up for all of us an explanation of what it meant by direct physical damage to property. Saturation, infiltration, ingraining. Ammonia, deadly ammonia that soaks into or gets all throughout a manufacturing facility. Gasoline vapors and gasoline that saturate a foundation of a church and get inside the building materials. And in Tritanic, methamphetamine vapors and smoke that infiltrate the building materials such that you have to hire 2 contractors, not just one to clean, but one to come in and renovate and tear out building materials that have to be replaced. That's what the SJC was saying when it talked about distinct demonstrable physical alteration, and it used the words saturation, ingraining, and infiltration. What do they allege?
2 questions, though, as it relates to Verveen. I think you were shaking your head when I asked, is it the same language that we're construing that Verveen construed? I understand the exclusion clause, but the basic language is the same.
Absolutely, Your Honor. And if I may, just to clarify, Verveen involved 3 separate insurance policies. I think Justice Desmond pointed this out. One of them, issued to Little Donkey, had a virus exclusion. The other 2 did not. It did not factor into the SJC's analysis. What the court focused on was, do allegations that virus contaminates the air and surfaces suffice to establish, to plausibly establish, direct physical loss of property or direct physical damage to property? The virus exclusion, in fact, they tried to argue in that case, was proof that we understood virus causes damage. And the SJC said, we're not going to go there. We're not accepting that, and it's contrary to precedent.
So my other Verveen-related question is, Mr. Levine sort of makes the argument that Verveen was narrow and left open this category of cases, and one of you quotes a question or statement that Justice Kafka made at the SJC hearing about trying to prevent people from amending their complaints and coming back in. So can you speak to that?
Absolutely, Your Honor. So context is important, but also when reading Verveen, context is important, but also the words that the court chose. And it's our contention, as you know from our papers, that the court intended to end the debate about whether coronavirus causes physical loss or physical damage. So why do I say that? Number one, when Verveen was my case, I argued it in front of Judge Sanders. When it got here, the SJC, we know this from the oral argument that happened later, the SJC knew that there were cases in the district courts and in the superior courts, some of which more specifically alleged virus is present and it's damaging property. They took Verveen from this court on their own volition and said, we need to decide this now. So when it gets to the SJC, what's the first thing that they did? They solicited amicus curiae briefing, and they got 8 briefs, including from Lawrence General Hospital, represented by the same counsel that represents them or represented them in the First Circuit. And what they did is they introduced an affidavit, a copy of which I have here, but it's in the SJC's record, from this virologist I mentioned from MIT, who goes on for, I think it was 15 pages, describing what he thinks are the physical interactions between a virus and surfaces, okay? That was before the SJC. They had that. Okay,
did the amicus here submit one in that case? UP?
I'm sorry?
The amicus here at UP, I think it is, did they submit one in?
They did, yes. Yes, they did. So they solicit the briefs. They're addressing that issue. We get to oral argument, at the SJC. And Justice Kafker points out, yes, these allegations in this case are more specifically addressing the effect of government orders rather than the effect of virus on property. But is it wise to decide the case on such narrow grounds? And he answered his own question, as the rest of the court did. And the rest of that argument focused on the same questions that are being presented here by Davios. The argument that virus causes damage, this, in particular, this virus, coronavirus, causes damage and causes loss. That's what the entire argument focused on. Then we get to the opinion. And if you look at footnote 7 to the opinion, Justice Kafker, writing for the unanimous court, says, we recognize that the trial court saw no specific allegations of this virus affecting property, but we infer that it was present from other allegations in this complaint. And if we don't draw that inference, they will simply amend and we will be back here for the court to decide this question. So context is important. Those things also are complemented by what the court actually said. And without belaboring the issue, because I've already talked about a little bit of it, they gave examples through those 3 cases, Western Fire Insurance, Gregory Packaging, and Farmers Insurance versus Tritanic, of what direct physical loss of or damage to property means where you have a harmful invisible substance, okay? And then they distinguished this virus broadly. They said at page 547 of the opinion, page 547, quote, as discussed above, the COVID-19 virus is different. The contamination is readily removable, returning the property to its uncontaminated state and allowing its continued use, close quote. They went on to say that this virus, at page 543, they went on to say that this virus has, quote, no direct physical effect on the plaintiff's property that can be described as loss or damage. And let's remember, they had that affidavit in the record that was submitted by amicus curiae to make the case for this virus affecting property. So here's the other thing I would point out to this court. As soon as this appeal was docketed in this court, what did the appellants do? They sought direct appellate review. And the arguments they made in their application for DAR were identical to the arguments that you're hearing now. Their argument was Verveen was very narrowly decided. And this court, that is the SJC, must correct the law to explain that it was narrowly decided and that if one comes along with, quote, more robust, more detailed allegations, more detailed than were present in the complaint in Verveen, that's enough to end run the court's decision, and now you have the opportunity to do discovery and everything else. That was the argument they made to the SJC. And in June of this year, the SJC closed the door. They said no.
You understand we can't read anything into that. They're a fickle lot on the second floor.
Good adjective to describe it, Your Honor. The point is, I would submit this as an inference, and perhaps the court doesn't want to join me in this, but if that court had agreed that its decision was so narrow, if it agreed that there are ways that one could plead that this virus causes physical damage or physical loss, one thinks perhaps that court might have said, we need to address this. But I'll leave that for our imagination about what the court's real intent was. I do want to, in my closing moments, and of course subject to any questions that the court may have, I want to really emphasize that the allegations of this complaint, if you read them carefully, paragraphs 73, 76, going on to 81, 85, 89, what they talk about is the same thing that Mr. Levine just explained to you when you asked him what's the damage. They talk about the threat to human beings and the spread of this virus among us, people. That's what they're alleging. When you asked the court asked the question, and I believe Justice Meade, you asked this question of him, what is the damage? His answer was the danger it poses. Well, it's dangerous to people, but let's be honest, and I'm sorry for stating the painfully obvious here, but this lectern cannot contract COVID-19 virus and go to the hospital. It doesn't get sick, but I do, and the court, members of the court may. So it's the threat to human beings. The virus, as the very first court to address this question, was the Southern District of New York in a case involving Social Life magazine. The court, it goes way back, and it was in a hearing, I believe, on a temporary, it wasn't a restraining order, but it was like a preliminary injunction seeking coverage. And the judge from the bench, I think it was Judge Cabrini, said, this virus hurts lungs. It doesn't hurt printing presses. That was almost 4 years ago. We're full circle. We're at the same place. And why is that? Why is it that our highest court, the highest courts of so many states across the country, and every federal circuit court has reached the same conclusion, that this virus doesn't cause physical loss or damage? It's simply because it's not plausible. It's not plausible. And so despite many more allegations in this complaint, much more heft, a more robust pleading, the plaintiff still has not and cannot plead that this virus causes anything that the SJC considered to be direct physical loss or direct physical damage. Unless the court has additional questions for me, we would rest on our papers.
Thank you. Exceptionally well done by both sides. I appreciate that. We all appreciate it. That's going to end our in-person component for today's session. I'd like to thank our court staff, our court officers, our clerk's office, and our excellent timekeeper. And with that, we'll stand in recess. Thank you.